All right, good morning, and welcome to today's oral arguments before the Kansas Court of Appeals. I'm Chief Judge Sarah Warner, and I'm joined today by Judge Karen Arnoldberger, who, of course, previously served as chief on this court for 8 years, and Judge David Bruns. We have just one case on this morning's docket. It's scheduled for 15 minutes of argument per side, and I know that we have seasoned attorneys who are arguing this case. So I want to thank you for all of your time on your written briefs, which we have thoroughly reviewed in preparation for today. We've also reviewed the court record and a legal memorandum prepared by a research attorney. So we are very familiar with the facts, and we encourage the parties to just dive into the legal issue that we have that's presented in this case. With that, I can call this morning's case. It's case number 127852 from Riley County, State of Kansas, Appellee versus Stephen Alexander Mitchell, appellant. Would the parties please state their appearances?
Good morning, Your Honor. May it please the court. Sean Randall of the Appellate Defender Office on behalf of Stephen Mitchell, present ready for argument. And Your Honor, I will be requesting 3 minutes for rebuttal.
3 minutes are granted. Thank you.
May it please the court, the state appears by Principal Assistant Solicitor General Natalie Chalmers.
Good morning. With that, Mr. Randall, you may begin.
Thank you, Your Honor. I'm going to begin this morning by doing something that one of my law professors told me to never do, which is try and tell you that a case is simple or easy, because if we are here arguing about it, then it certainly must not be simple or easy. But I think the resolution of this case is pretty simple and easy, as long as this court takes into account two longstanding fundamental principles that have always been applied by our courts. The first is that the fundamental rule of sentencing is that the sentencing provisions in effect at the time the crime was committed control, in the case. That's been cited in Keel, and I think I found a case going back to at least 1991, and I think cases even before that probably held the same thing. The other fundamental principle that I would ask the court to take into account and apply in this case is that defendants are entitled to benefits in the change of the law while their cases are pending on appeal. So what we have in this case is that Mr. Mitchell committed his crimes in June and August of 2023, and the amendments that the state is asking this court to apply to Mr. Mitchell did not come into effect until May of 2024. And so those amendments did not exist at the time he committed his offense. And in fact, the only thing that existed at the time he committed his offense was the version of 6615 that was interpreted by Hopkins and Irvin to say exactly what it says, which is that you get credit for the time that you're in custody pending disposition of the case, regardless of whether that case, regardless of whether that time is applied in another case. We also have, I think, the fact that
excuse me for just a minute. At the time he was sentenced, had Irvin been decided?
Irvin had not been decided at the time.
Okay, so we had Hopkins, but not Irvin.
That's correct, Your Honor. That's correct.
I just wanted to clarify that. Okay, go ahead.
But certainly Irvin was decided in April of this year, and his appeal was filed in June of 2024. So Irvin was decided while his case was on appeal.
And had Fikert been decided when he was sentenced?
I don't recall specifically, Your Honor, but there was no discussion of Fikert during the sentencing hearing. And I would expect if it had been decided, it likely would have been referenced by either of the parties. And so
I can look back on the dates. I just didn't know if you remembered.
My assumption would be that Fikert had not been decided by the time that he had been sentenced.
Okay.
And speaking of sentencing, I think it's important for this court to take note of when he initially appeared for sentencing on May 20th of 2024. That was before the statute had been amended and before it had gone into effect. And it was only the judge's decision to continue it and extend it until after the statute became effect that we're even in this position to begin with. I mean, when they appeared for sentencing, they discussed the number of months he was going to be serving in the Department of Corrections. I mean, they got pretty much all the way through the sentencing there on May 20th. And it was only the discussion of jail credit that, you know, the court decided to extend it beyond that May 23rd date. That really kind of controls in this case.
Counsel, as you point out, typically we say that changes in the law, or we use the law in effect at the time that the person commits the offense to govern things like the sentence and other kind of corresponding aspects of their sentence. There's some language in Ervin that kind of is a comment that makes it sound like the Supreme Court at the time was thinking it was the law that was in effect at the time of sentencing, not at the time of the commission of the offense. Have you looked at that language, and do you have a response to that?
I'm not necessarily familiar with what part of Ervin you're referring to, Your Honor. I think the holding in Ervin is pretty clear. The individual who committed his crime again prior to the amendment got the benefit of the amendment as it had been interpreted in Hopkins, and they just clarified that means exactly what Hopkins said, which again was that.
Of course, I mean, at the time, the court said and made very clear that it wasn't considering the retroactivity of the statute because none of the parties had raised it, which makes it different from the case here, which that issue is front and center.
Correct, and I think it's good that we're talking about retroactivity because I think what the court obviously is trying to do here is to divine the intent of the legislature, and we know that sentencing provisions are generally construed to be prospective unless there's an express, an expression in the statute that it's supposed to be applied retroactively. And I would note that obviously there's no statute or there's no language regarding retroactivity in 6615. And I think that's incredibly important because our legislature has shown, I'm sorry, did I interrupt? Oh, okay. Our legislature has shown that it knows how to respond to decisions of the appellate courts of this state by amending statutes and adding retroactivity language. I would cite back to 2014 when the first Murdoch decision got, handed down. They ran to the legislature. They said, we need a fix, we need a fix, we need a fix. And they ended up amending, 216810, and included language that says, the amendments made to this section are procedural in nature and shall be construed and applied retroactively. They use the word explicitly, and they know how to use that word in the statute when they want something to apply retroactivity. It's the same thing in 2018 and 2019 in response to Wettrick. Again, there was this clamoring that we need to fix this, legislature, we need to amend the statute, we need to change this, and that's what they did in 6811, 6820, and 3504. All of it includes that same language. Again, the amendments made to this section by this act are procedural in nature and shall be construed and applied retroactively. Our legislature knows how to use language to specify when something is supposed to be retroactive. I think all of those statutes and probably more are evidence of that fact. And all of those statutes were amended in response to appellate court decisions. And that's the thing. Hopkins was decided. There was, again, a run over to the legislature to say, we need to amend this, we need to amend this. They did amend it, but they didn't include any of that retroactivity language. And I think that's telling to indicate that there is no expression in the statute that it's supposed to be applied retroactively.
Counsel, if we were to adopt your argument on that the legislature did not put a provision in to make this amendment retroactive, do we even need to reach the ex post facto clause?
No, Your Honor, and I'm glad you asked that. I mean, I think the only way that the ex post facto argument even really comes into play is in, I think, differentiating the King case that the state cited in their brief. In the King case, the reason why at least that result was acceptable was because application of the statute resulted in an increase in an additional award of jail credit. Obviously, the application of the statute in this case would result in the taking away or the disadvantaging, the defendant. And so I think there is an ex post facto difference between that case. And I think there's a lot of other differences between that case and the one at issue, as well. But I think the only reason that ex post facto might be addressed is if there was some concern that somehow this pre-KSGA case from the Court of Appeals, discussing probation revocation context, was needed to be addressed. But no, Your Honor, I that's why I started this off with saying there's two fundamental rules, and both of them, resolve this issue without having to address ex post facto. Does the panel have any other questions?
No.
Okay.
I think you anticipated my next question, which was how would you distinguish King, and you told us how you would.
Well, I think the important thing, and again, if I'm snatching victory from the jaws of defeat, then I'll run that, or I'm snatching defeat from the jaws of victory, whatever it happens to be. I'll run that risk. But I did want to highlight what the court was doing again in King, and what the court is trying to do here today is divine the intent of the legislature. That's always what this court is trying to do when interpreting statutes. And I would note that the biggest difference in King is I think there's a mistaken reliance on the state by indicating that King was dealing with an amended statute. That's not what King was dealing with. King was dealing with a brand new statute. It was, I think, 4116A versus the original 4614. The fact is there were two statutes that were competing, and that's what the court was trying to decide. I understand why the state might want to call it an amended statute, but because that's what happened here is because there was an amendment. But that's not actually what happened again in King. There were two different statutes, and the court primarily, I think, based its ruling on the fact, on the general versus specific intent. And they said there was a general provision and a specific one, and the specific one was designed. So any kind of interpretation based on this other extraneous statute, I don't think necessarily applies. But again, I think it's the intent of the legislature and the proof that we've had multiple attempts at the legislature to correct or fix or amend statutes in response to appellate court rulings. They did that here in Hopkins as they had done previously. They used the word retroactive explicitly in the other ones, and they certainly didn't do it here, and that's why it doesn't apply. With that, I'll wait to see what the state says for rebuttal. Thank you, Your Honor.
Thank you, counsel. Ms. Chalmers?
May it please the court, the state actually intends to address two variants of the jail credit issue today. First, what it means to be pending disposition of the defendant's case, and then second, the jail credit issue that was just discussed. There's actually another issue in this case. The defendant is trying to seek jail credit from the day the case was charged. In his other case, he actually got it from the day he was arrested, but here he wants it in this particular case from the day he's charged. Is the state's position that the language pending disposition of the defendant's case cannot go into effect until after there is a charge and then there is an arrest on that charge. The defendant is not in custody on that case until there is a arrest in that case. That question is not answered by Irvin.
Did you raise that in your brief?
Yes, it is raised that, let me pull that brief real
I
quick.
don't recall, I may have completely missed that, but I don't recall seeing that in your brief at all. Any kind of dispute as to how, if counted, how many days are counted?
It is in the statement of facts that he talks about how he's originally, the appellant was originally asking for 285 days, and now we're down to 257. You might
But
be
you
right.
didn't argue the number of days in your brief, or whoever filed the brief didn't.
Yeah, that's true. Yeah, you might be right.
I think I'm right.
Yeah, I know. You're very right. I'm sorry. I don't know why I thought that was in there. I think I read it in the brief of the facts and thought that was part of that. So if I can't raise that, that's fine. I do think, though, you're questioning what kind of jail credit he gets. And he's asking for this day, and this court needs to be assured that he is, in fact, getting the right credit. And so you have to know you still have to decide what pending means. And pending to the state means, again, post-arrest, post-charge.
And counsel,
that-
if this case were to be remanded for resentencing, I suspect the number of days could still be argued, or where was it stipulated to here?
I don't think there's any stipulation. There's a dispute about the number of days. I do think that in the brief itself, there's a dispute, and I do think in the reply brief, he's now saying he only wants 257 days, and the state seems to think that he only should get 256. So it's not a huge difference. I certainly am not opposed necessarily to a remand where the district court figures it out, and that could also let us potentially go into the other case and take out a few days of credit that he shouldn't have gotten, if the word pending at least means when the case is charged, because he got credit then prior to the case being charged. And this is a dispute that keeps happening in these jail credit cases, which for some reason wasn't happening before. And it goes to the state's point that you, of course, can't care that much about that Irvin is wrongly decided, that the statute is not as clear as the Kansas Supreme Court seems to think it is. We do not know what pending disposition of the defendant's case means. It is ambiguous, and Irvin is wrong. But going to the jail credit issue, that is the crux of this case with the 256 or 257 days of credit. It is notice, or in Irvin, the Kansas Supreme Court did say KSA 216615 as worded when Irvin was sentenced. So the Kansas Supreme Court specifically referenced the statute in effect at sentencing. And if we're going to take Irvin,
Counsel, do you think that that was an intentional setting aside of this longstanding principle that typically we apply, that says that the law that was in effect at the time of the offense is what governs?
I cannot define the Kansas Supreme Court's intent. I think that they usually are better at using the language, and they've certainly told the state before and the defense before that this is the statute that applies because it was at the time of conviction, and they specifically chose to use sentencing here. And they may have done that because the state made no arguments about how the statute should apply. And so they may have noted that there's a possibility that the law in effect at sentencing applies. I think it's an open question. I don't know that that is 100% controlling, but it's certainly persuasive that the Kansas Supreme Court thinks it's the statute in effect at the time of sentencing. And
it would
apparently
seem like a strange rule, because the person would have been held before sentencing. They would have spent all of the time held in jail before sentencing, and so then you just have an intervening rule that comes in that would then change the way that that would be applied. Doesn't that seem strange to you, or is it just me?
It is not entirely unheard of. That is what essentially the Kansas Supreme Court did in State v. Patton. State v. Patton is a DUI case. There is, contrary to counsel's assertion, absolutely no retroactivity language in State v. Patton, but the Kansas Supreme Court looked to the language of the statute itself and said, based on the statute itself, we think the legislator intended that the statute applies at the time of sentencing. Here, because you cannot do jail credit until sentencing. That's when it's done. It's either done at sentencing or probation revocation. The language that says in any criminal action seems to indicate any case in which a defendant is being sentenced. That's what this court held in King. And while defendant points out that it was a different statute, that language was in both versions of the statute. It was in the 216414 and 21614A in 1989. The amendment to the statute, it was in fact amended. It used to be that the rule was that jail credit was discretionary, and that was across the board. It wasn't just for probation violations. And then at some point, the Kansas legislator said, it's not discretionary anymore. You have to give it. Here's our rule for it. Again, we think that the language allows for that. We think it does patent. And by the way, the state is not even actually trying to argue that this is truly a retroactive statute. If it were a true retroactive statute, it would apply to all cases that were still going through litigation right now, even if the defendant had already been sentenced. But we're only saying that the statute applies if the defendant was sentenced when the statute was in effect. So we're not trying to do a true and complete retroactivity argument here. We're saying plain language of the statute says this is what the legislator intended. And what's even more clear is we went to the legislator under Hopkins. Hopkins did not say that this applies to consecutive cases. This court knows that. It decided differently in Fikert. Fikert was, in fact, decided after the sentencing in this case. It didn't say that. It wasn't even being argued. All that was argued in Hopkins is the same rule that the state would still like to be the rule. The defendant gets 1 day of credit for 1 day in jail. That was a dead credit case. We realized that there was ambiguities in the Kansas Supreme Court's decision. We saw them from opinions by this court, and we saw district courts start to give duplicative credit. So we went to the legislator in hope of trying to avoid additional years of litigation about whether or not Hopkins really meant consecutive credit. And what I said to the legislator when I went there with that statute was, tell us what you want. We agree that Hopkins's rule is actually the fair rule. We think dead credit is probably not fair. And so we're fine with codifying Hopkins. That was done in the new statute. But we do not think that this legislator has ever intended for duplicative credit to count. Multiple members of the legislature who happen to be attorneys agreed and said, no, that would be a strange thing for the Kansas Supreme Court to think would happen. And then they came up with this.
This is all very interesting, Ms. Chalmers, but none of this is in the record, right?
Oh, sorry. I'm so used to the briefs that I've written in other cases. Yes.
I don't think
Well,
any
you
of this-
can look at legislative history if you're just trying to
Well, I
decide.
don't know that we can look at what the Attorney General's position was and why they took one position over the other. I think we've gone kind of far afield here. Although
Right.
interesting, I don't know that we can consider that either. And again, I know you're under some, you're hindered a little bit because you didn't write this brief, but I don't know that we really want to hear all about what the legislative thought was.
All right, and that's this court's prerogative. I will say that if we're going to open it into legislative interpretation, legislative history is typically part of that. And that's what I was commenting on. And there is a recording of the proceeding that this court can watch if it is so interested. I will,
Counsel,
I have
however,
one
move
more
on.
question. I have one
Oh.
more question. Do you draw any conclusions from the fact that Hopkins did not specifically overrule Davis or Lofton?
Correct.
And
I
why
did.
do you think, is there anything that we can gain from that at all? Or was it just an oversight on their part that they did it in effect, although they didn't say they overruled those two cases?
I more think that that's actually relevant to the legislative intent here, because when Lofton and Davis still existed, the legislator was then codifying existing law, that there was no duplicative credit. The legislator in this statute codified that law. As to why the Kansas Supreme Court didn't touch upon Lofton and Davis, that is a mystery to the state, especially since in the Hopkins supplemental briefing, Davis was cited. So I'm not entirely sure what happened there. I respectfully agree. Well, I continue to agree with Fikert. I think Fikert was correctly decided. I think that Irvin hasn't dealt with how in the world this works in consecutive sentencing and why there's not a conflict with 216606. The state's just kind of befuddled by Irvin and would like to see the Kansas Supreme Court kind of show their work a little more so that we can understand and accept it and hopefully end these jail credit cases someday.
Counsel, the fact that these amendments last year were published in the Kansas Register rather than just going into effect on July 1st, is there anything that we can, is there anything evinced from the legislative history through that date, or is it just, let's get this into effect as soon as possible?
The actual date itself, I don't know, but it is, the Register of Publication is unusual. It was specifically asked for because we wanted to end the litigation as quickly as possible because district courts were reading Hopkins differently. And this court had not yet come out with Fikert to clarify this court's interpretation. So we just wanted the legislator's intent to be clear in such a way that no district court could have to sit there and try and figure it out anymore. And that's what the publication happened quickly. We asked for it and they gave it to us. So I think I've covered all of my points, but for those reasons, the state would respectfully request, oh, no, I haven't. Let's talk about ex post facto. So here, ex post facto, at the time the defendant committed his crime, the rule was no duplicate of credit. That was the rule. It had been in the rule for 45 years. He was convicted prior to Hopkins. Even Hopkins, again, did not say that duplicate of credit was the rule in consecutive sentencing cases. That happened after he was sentenced. On the date of sentencing, this statute went into effect. Prior to his sentencing, this statute went into effect. That's the same rule, no duplicate of credit. So there's no ex post facto here. We're not increasing this punishment. That's the state's position. And for all of the reasons I stated today and in the brief, the state respectfully requests that this court find that the statute that was in effect at the time of sentencing controls and duplicative credit is barred.
Thank you, counsel.
Is there any, I mean, what should we conclude from the fact that the judge specifically continued the sentencing to make sure that the new statute was in effect?
Well,
I mean, that's kind of manipulating the outcome, isn't it?
I don't know if there was an objection to that. I don't remember what happened, if the judge was just saying, hey, we're going to get an answer on this one way or the other. I will agree that it's not the ideal fact. And
because it
to the
seems like
extent-
if you can manipulate it by just saying, well, we'll just continue it until the statute goes into effect, that doesn't seem to be a fair result.
If the defendant had been sentenced prior, the judge still could have come with the same rule, and then the state would be making the same arguments it's making in all the other cases, which is Irvin is wrongly decided. And we will continue in every case that we can to petition to try and get that decision in front. So if this court were to rule and say the statute does apply, if we go to the Kansas Supreme Court, which I assume both sides are going to go regardless of the outcome in this case, well, we're going to try. I can't make the Kansas Supreme Court take my cases. Another thing that could happen is the Kansas Supreme Court could do exactly what it did in Keel, which is say, nice statute, we don't have to care anymore because our decision was wrong in Murdoch, and in this case, our decision was wrong in Irvin, and we can, again, get an actual end to this jail credit issue.
Any other questions from the panel? All right, thank you, counsel.
Thank you.
Mr. Randall, you reserved 3 minutes for rebuttal. Oh, Mr. Randall, you're still muted. Yeah. Before you begin, Mr. Randall, where are the blue books? I see all the yellow books. Where are the blue books?
You mean behind me?
Yeah.
Oh, well, you can get a hold of Mr. Lawless and determine whether or not that's his purview.
All right.
What I was trying to say, Your Honor, is that I don't know whether or not I'm going to need all 3 minutes, but I did want to respond to a few things. The state was saying towards the end of its argument that you know, the rule in effect when he committed his crime was no duplicative credit, and that was, you know, what Campbell had said, you know, for 40 years, and I understand that, but again, the principle is not what is the rule. The rule is what are the sentencing provisions. The sentencing provision was KSA 2166-15. That's what was in effect, and it was the same version of it was in effect when he committed his crime, as obviously was in effect, you know, prior to the amendment. And I think there was a question at the beginning about, well, Irvin said this is the law that was in effect at his sentencing, and so that's obviously what, you know, Irvin was trying to say. And I think Your Honor, you know, may have mentioned it, that, you know, don't we think that if they were trying to overrule this longstanding principle that you know, governs it at the time he committed the crime, they would have been they would have said so, and I think the answer is most certainly. That's again been the case law of this state for even before you know, again, the the KSGA is concerned. And so, yes, I think they would have been explicit if they were intending to do that. The state also tried to make an argument that somehow pending disposition can only be from the date he was arrested. I don't think that's what disposition means. I believe your case begins when you are charged with a crime. And I don't think that really affects anything other than, again, what time did you spend in custody while your case was pending? In this case, it was 257 days. If the court wants to find it's 256, I suppose I concede that point. I think the only other thing I wanted to address was the state's contention that Hopkins did not answer the question or address consecutive sentences. Exactly, but Ervin did. And Ervin was decided while pending appeal. And again, that's the other longstanding principle, that the benefit of the change in the law applies to cases while they're pending on appeal. And Ervin was decided while his case was pending on appeal, and Ervin makes it very clear what we're supposed to do in this case. Does the panel have any other questions, though? Okay. Thank you very much, Your Honors.
Thank you both very much. The court takes the matter under advisement. We'll render an opinion as soon as we can. And at this point, the court stands adjourned. Thank you.